Welcome back to the Emily Show. There is a lot going on in the law, as always, and we are on the precipice of the Karen Read trial starting. So, we need to talk a little bit about that. Big things happened in court this week in the Kohberger case and in the Kouri Richins case. And Diddy is trying to drag Warner Brothers into court. We need to talk about it. So, buckle up. Let's ride. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. As we get into spring, there is more than enough to worry about, but you know what you shouldn't worry about? Throwing your hands in the air like you just don't care during the upcoming summer concert season, and that's why today's sponsor, Lume, is my go-to for full body deodorant. Not only is Lume formulated to work on all of your parts from pits to feet, and yes, it does work wonderfully on feet because I don't want my dogs to stink and I have 2 teenage boys in the house. If you're familiar with Lume, you know that they outperform other deodorants with long-lasting odor control. But what you might not know is Lume also has new deodorants plus sweat control, and they come in a solid stick if you don't want to use the cream in a tube. So not only can you pick between deodorant and deodorant plus sweat control, but you can pick what form you want your Lume in. And if you're new to Lume, the starter pack is perfect. It comes with a solid stick deodorant, a cream tube deodorant, and 2 free products of your choice, like the deodorant wipes or the shower gel, which I love. Plus you get free shipping. And as a special offer for Emily Show listeners, new customers get 15% off all Lume products. And if you combine that with the discount on the starter pack, it's more than 40% off the starter pack. Use code LAWNERD for 15% off your first purchase at lumedeodorant.com. That's code LAWNERD at LUMEDEODORANT.com. And don't forget to let them know that the Emily Show sent you. Smell fresher, stay drier, and boost your confidence with Lume. Let's get back to today's episode. A quick programming note, because things are going to be changing around this YouTube channel just a little bit. You might notice that it is now called The Emily Show. Well, that's because this is where the podcast lives now, and you guys have been absolutely loving the Emily Show episodes, covering multiple cases in one episode, and then doing the deep dives on the live stream channel at the Emily D. Baker. A lot of you are staying in the loop with the LawNerd app, which will let you know when every episode drops and will keep you up to date on the cases that you care about most. So, as we get into 6+ weeks of trial, what's going to be going on the Emily Show channel and the audio feeds are the episodes on Monday, unless court gets wild, and then I'll let you know, and the kind of day-to-day case briefs of the Karen Read case, where we clip down kind of my summaries of the day and highlights from court, and those will be dropping so that if it's a case you're not watching in real time or just want a summary of what's happening day by day so you can stay in the loop and jump onto live when it works for you, that's what's going to live here. And then I will be live streaming gavel-to-gavel over on the Emily D. Baker channel. So again, if you want to stay in the loop with everything, the LawNerd app is the place to be. If you like those kind of case briefs that we pull together from the full court days, let me know, because I think they are fantastic. Team Baker has been doing a great job of making sure you don't miss what's in court and you know where we're at as these cases are moving along. And the briefs and the streams from what I talk about today will all be linked down below if you want to see, a more fulsome picture of what we're talking about. First, in talking about the Karen Read case, it looks like this case is going to be starting trial with opening statements, possibly as early as Tuesday, April 15th. So again, I am going to be streaming that gavel to gavel, and it looks like Alan Jackson might be doing the opening statements this time instead of David Yannetti. And we'll see if the opening statements start with
Karen Read was framed,
or if they are going to be moving towards this investigation cannot prove to you what happened to John O'Keefe. And that is a tragedy. It is unacceptable, but it also shows you that the government cannot prove that Karen Read did this. We're going to see if they lean in to that Bowden Defense, as they call it in Massachusetts, based on case law, where you see argument about the investigation, you see argument about Trooper Proctor. And how many times is Trooper Proctor going to get thrown under the bus? I think the limit does not exist on that, because it seems to be where the Commonwealth is going to. So is that the direction of the defense that we will see? Because I think it's simpler for jurors to understand this investigation does not give you proof beyond a reasonable doubt. I think it's much easier than saying all of these people are in on something, because a lot of people are just not going to follow that, especially in a trial where the judge limited closing arguments to just an hour. Keep it simple. We'll see what happens though. But Karen Read had appealed all the way through the state Supreme Judicial Court in Massachusetts and now to the Supreme Court, the federal Supreme Court. The Supreme Court with Judge Jackson denied Karen Read's stay. That doesn't mean that they're not going to take up her writ of certiorari. It doesn't mean they're not going to evaluate the question. It means that they're not going to tell Judge Cannoni to stop right there, thank you very much, and not go forward with the trial. So the trial will still go forward when they have 18 jurors selected. There had been reports that the judge was going to stop with 16, which they have. I think 18 is the wise choice given the length of this trial and the high profile nature, because you may lose jurors as you go. And so having that many alternates when you have 12 deliberating and then 18 total gives you a little bit of space if jurors aren't able to complete the full trial, are exposed to media, or some other thing happens, life happens. So the Supreme Court on April 25th will take a look at the brief, and then after that decide if they are going to take up the question of whether or not this trial violates Karen Read's double jeopardy rights. It is a difficult argument for the defense. Courts do not invade the province of jury deliberations. And though I think there is room to split hairs on that, the courts are hesitant to do it because it could be a slippery slope. I do not think we will see the Supreme Court taking up this question. I don't really know if the question is ripe to take up, though the defense made some arguments that it was. I will be interested to see what they do, but I am not thinking that it is more likely that the Supreme Court will take it up. I think it is much more likely that the Supreme Court will not take up this petition. The trial will go forward, and then, depending on what the end result is, all the appellate process may begin again. So with regard to the Karen Read case, it's just time to
bring the jury.
And we'll go from there. I guess we can't really move on from the Karen Read case because the Karen Read case got name-checked in court in Utah in front of Judge M in the Kouri Richins case. You might not recognize this case by name, but this is a case of a woman who's accused of poisoning her husband with a Moscow Mule. It took over a year for her to be arrested. It seems largely because it took that long for them to crack her cell phone and get into the phone that they had retrieved via a search warrant, and then start to find the text messages and Facebook messages and what have you that seem to have led to the arrest and further investigation. But Kouri Richins is the one who was out on a bit of a local book tour about her book regarding grief and talking about navigating as a widow with 2 young children and how she was helping her children deal with the loss of their father. Yes, the loss that she is now charged with causing. She also wrote that walk the dog letter that seemed to strongly indicate what her brother and mother should say in court because it would be helpful to the defense, that case. Well, that was supposed to go to trial at the very beginning of May. I've been interested to see how this trial plays out. The lawyers are interesting. The judge has the greatest voice of anyone on the bench. Apologies to all other judges. You're not going to get there. And there are still facts that are unknown. There is still an evidentiary fight over whether or not the walk the dog letter comes in. And then there was a notebook that may or may not come in. And so there are some really interesting things legally still happening in this case. And I was ready for this case to go to trial. I was a little frustrated that it might overlap with the Karen Read case. Well, all things seem to just work out when it comes to conflicting trials because the Kouri Richins case has now been delayed indefinitely due to an interlocutory appeal. That is an appeal that is happening while the case is ongoing, not an appeal that happens after something is resolved. The judge denied a motion to change venue, and the expert for the defense was the same expert we saw in the Kohberger case. We heard lots of discussion about the Kohberger case, the O.J. Simpson case, and yes, the Karen Read case, because the defense started arguing that Kouri Richins was an outsider, that her husband's family is very prominent in Summit County, that there's a library with their last name on it, and that he was the local and that she was an outsider. Though the court pointed out immediately, didn't they both move here in 2012 together? So the court pushed back on it a bit and seems to be a bit of a statistics nerd, because as the court was questioning the expert, and the court's like, I have questions, let me work. The court was asking about the standard deviation and other ways the data maybe was presented to him to look more favorable. And the court was saying, well, when you take this percent of that percent and add and add and add, then isn't it really this? The court was tremendously ready for this motion and said, I don't think that you have met the burden to prove that Kouri Richins cannot get a fair trial here in Summit County. And then said, if the appellate court's power that be disagree with me, then I think the solution is to bring a Salt Lake City jury to Summit County to decide this case because of the close proximity of them. And there were some notable differences from the Kohberger case that they pointed out. One of those big factors really was as the court called it, kind of an inflammatory plus factor, because that's what the case law calls it. And in the Kohberger case, some of that was the stress, anxiety, and fear of the community over the 6 weeks from the killings at King Road until somebody was arrested. That period of time where people were deeply invested in figuring out what happened, where the public felt unsafe, that can last with a juror, even if they say they can be fair. There is a visceral reaction to that, and that's not the case in the Richins case. In the Richins case, it seemed to be reported that there was a overdose death, whether it was accidental or otherwise, and there wasn't much more about it. There was no concern to the public. There wasn't anything hyper sensational about it. And the book tour was covered, but not in connection to any crime until she was arrested. So the court really seemed to differentiate between those things in denying the motion, but the defense said immediately they're going to appeal it, and the case is put on hold until that appeal is done. So I will keep you posted whenever Kouri Richins is back in court. And maybe, just maybe, between now and then, the court will decide that he doesn't absolutely hate all of the media and wants this case to stream, because otherwise we're going to be at least on a one-day delay to get feeds out of Utah, because the court does not want this case streamed. And I am just sad about it. But he's not happy with headlines about the case. He is not happy about the coverage of the case. He said that it was unbalanced and incomplete. So the court is not pleased. And I have to wonder if we're going to see more courts bringing up the same thing in other cases, because now we are seeing more and more these docuseries about cases that are dropping before they go to trial. It has come up quite a bit in the Karen Reed case with her giving interviews, but in other cases, including the Murdaugh case, we are seeing docuseries drop prior to any trial. And that's what Diddy and his lawyers are arguing about. With the Diddy criminal prosecution, even though there was that additional superseding indictment, it does seem that all signs point to this case going to trial in early May, which is still shocking to me. And I will still be surprised if this starts jury selection at the beginning of May, but I guess we're not that far away from seeing if that's true or not. And as they are getting ready for trial, Diddy's lawyers are trying to subpoena the unaired, unedited interviews of participants of the Fall of Diddy, which is a Warner Brothers production that I think aired on Max or Hulu or something. Emily, tell me you haven't seen the Fall of Diddy without telling me you haven't seen the Fall. I haven't. I just haven't. So Warner Brothers Discovery is asking the court to quash the subpoena, meaning they are asking the court to tell Diddy's team, you're not getting the shit that you asked for. They say the subpoena should be quashed on two separate and independent grounds. First, the subpoena, even as modified through the parties' meet and confer discussions, the lawyers emailed back and forth, hopped on the phone, and tried to narrow this down. They say it exceeds the limited scope of Rule 17C, amounting to the kind of quote-unquote general fishing expedition that the federal rules of criminal procedure prohibit. They say, second, even if the subpoena is proper under Rule 17C, the interview outtakes it seeks are protected by the reporter's privilege that applies to unpublished news gathering materials. I am interested to see if the video of an interview that was edited are news gathering materials. Yes, it's unpublished. I'm interested to see how the court rules on that, because I don't think this falls under a general fishing expedition. The subpoena is actually fairly narrow on what they ask for, which is interview regarding two individuals. And they narrowed that down through the meet and confer process. So I don't think it is exceedingly broad. Whether or not it's met by reporter privilege is different. And this is going to be different than the ruling in the Karen Reed case because the reporter privilege in New York is much different than the lack of reporter privilege in Massachusetts, which is why we saw in the Karen Reed case, the news entities that are based in New York saying, no, we're not consenting to jurisdiction in Massachusetts. Come to New York and ask us again. Come up here and ask us to our face. And the prosecution dropped it immediately. The reporter privilege in New York is much stronger, and that doesn't surprise me with the amount of media outlets that are based in New York. This is similar to LA, where you have more media based. Shockingly, there are more cases where this comes up, and the lawmakers tend to have this on their mind more because the businesses that are there ask them to take it up. Warner Brothers Discovery says the documentary series was the product of extensive reporting, including on-camera interviews with, among others, individual A and B. And those are redacted. They say at the court's request, WBD, Warner Brothers Discovery, would be happy to provide a complete copy of the docuseries along with time codes identifying the relevant interviews. Individual A and individual B are identified in the unredacted copy of the subpoena, which WBD will provide separately to the court. So I appreciate that all the attorneys in this have gone the extra step to keep these individuals' identities about who is being subpoenaed more neutral, though those interviews did air in this docuseries. And I don't know if the docuseries blurred faces or voices or anything like that. I have not watched it. They might have. They say request 1 is all recordings of interviews with individual A or individual B created in connection with the documentary series, including unaired outtakes, and all, quote, diary entries, journals, narratives, and notes provided by either individual A or B. That's probably broad. Request 1, not so much. They go on to say that courts have consistently held that broad requests for interview outtakes without any specific reason to believe the outtakes contain any relevant, non-cumulative statements are inconsistent with Rule 17C. This is going to come down to what's in the interview and if those individuals might be witnesses in this trial. They then argue that the Second Circuit has long recognized a qualified reporter's privilege, which applies in both civil and criminal cases, and to both non-confidential and confidential news gathering and source material. The privilege applies to, among others, documentary filmmakers. They cite United States versus Grant applying privilege to a criminal subpoena seeking outtakes from MTV series True Life. And then they cite a 2022 case only identified by Shaw, applying privilege to criminal subpoena seeking outtakes from ABC documentary about criminal charges against a reality television star. Yes, they are talking about Jen Shaw. And yes, I covered all of those filings when they sought to get outtakes from ABC, the Housewife and the Hustler, or whatever the Shaw Housewife and the Hustler was called. Emily, were you in the second Housewife and the Hustler with ABC? Yes, I was. But we went through all the court fight over that, and they were trying to get to law enforcement interviews. But those interviews didn't seem to clearly be interviews of people who would be witnesses in the criminal case, where it seems here that these individuals could be witnesses in this case. And I think that'll be a large factor here. They go on to cite the Shaw case again, saying that it quashed the subpoena for interview outtakes from documentary where criminal defendant failed to identify any particular outtake that would provide the evidence she sought and instead sought wholesale exposure of press files to litigant scrutiny. And again, this is a difficult thing. How do you know what the outtakes will contain? And I think if these individuals are individuals that might be witnesses and they are talking about interactions with Combs within the period of time that he is charged with a very broad RICO statute, the broadness of what Diddy is charged with may in fact lean in his benefit in this very narrow way, because if they're talking about interactions with him, that is going to be relevant based on what he's charged with and the way he's charged. Different than in the Shaw documentary, where with law enforcement, they were talking more broadly about fraud cases, and they weren't specifically talking about interactions they had personally had with the defendant. Once you start talking about the defendant, then it becomes more relevant and more likely to be admissible. And it becomes a little easier to say, well, they were talking about interactions with Diddy. It's reasonable that outtakes might include that. But again, it becomes hard to prove. How do you prove what's in what you haven't seen? The court responded to this on April 8th, almost immediately, and said Warner Brothers Discovery, Inc. filed a motion to quash a subpoena served on it by defendant Combs, docket 218. Any response should be filed by April 10th, 2025 at 12 noon. So ordered. Guess who didn't file a response? Yep. The government did. The U.S. attorneys said, hey, we agree, don't turn it over. But the defense didn't respond to this, which I find very interesting. And with the defense not responding, I wonder if the court will even address the question of reporter's privilege, or if the court will just grant the motion because there's no response. I think we'll see early next week what the court does with this. And finally, let's talk about the marathon hearing in the Bryan Kohberger case. The Bryan Kohberger prosecution is moving towards trial, starting with opening statements in the beginning of August. It seems that jury selection should be starting in July, but the defense has already made some rumblings about the fact that they haven't gotten through all the discovery, that they have not had enough time, and that there are concerns that they might not be able to adequately defend this case because of the way the discovery has come in. And the court pushed them on that at the hearing and said, why didn't you bring this to me sooner? The defense asked for the court to take the death penalty off the table as a discovery remedy, saying that the way discovery has come in from prosecutors has made it impossible for them to do their job in the diligent manner that's required for a death penalty case. They very much were leaning on rulings in Idaho in the Lori Daybell case, where there were discovery violations, and as a remedy for that discovery violation from prosecutors, the court said the death penalty is no longer available, even though the state was seeking it. This is not the same. We're not dealing with discovery violations, and there have not been motions regarding discovery violations. We're dealing with voluminous, unorganized discovery. But the defense outside of the AT&T records isn't saying there is stuff that the prosecution still hasn't turned over to us. They're saying the prosecution has turned over so much, 68 terabytes, that we can't possibly go through it because it's not meaningfully indexed. It's not easy to find. Things are inside folders, inside subfolders, and you can't search through it. And there are terabytes and terabytes of video that we have to go through. And they asked the court to tell prosecutors to identify the key documents as they see them. And the court pushed back, saying the problem with that is that if they identify things and then you find something outside of what they identified and you disagree, then it creates an issue that doesn't need to be created. The prosecution and the defense have to exchange exhibit lists coming up this month, and then the defense will have all the exhibits the prosecution intends to use. But I'm empathetic with the defense in this because it's a ton of video to go through. It's a ton of documents to go through. However, the prosecution has said they're turning over things in the way that they're receiving them. And I don't doubt that because they're dealing with so many different agencies. They've said that not every agency indexes the discovery. They turn it over, and then the prosecution turns around and gives it to the defense. So we saw over 27 motions heard last week in the Kohberger case. The court ruled on some of them that were easier and a little bit more pro forma. And yes, you can't, call the defendant a sociopath, obviously not. And yes, everyone needs to adhere to the rules of the road. Lawyers have rules, you must follow them. But then reserved ruling on other matters. But you could see where the court was maybe disinclined, and you could see where the court pushed back on prosecution with things like the sequestration order or exclusion order regarding the defendant's family. If any of them are going to be witnesses, the court pushed back on either calling those witnesses very early in the case so they can watch the trial, or allowing them to sit in until they need to testify, and asking the state to be mindful about that. And if those witnesses who are not percipient witnesses are coming in to testify about Amazon accounts or what have you, they shouldn't be excluded from court because testimony of other witnesses isn't going to change what they say. It's not like their memory about how they search Amazon is going to be impacted by what other witnesses in the case have to say. And I think the court's pushing back on that against the government was fair. He gave them choices. The government might not like the choices that were given, but I think the court gave them fair choices. Either don't sequester them and let them sit in the courtroom, or call them as some of your first witnesses. And that's how we saw it handled in the Karen Reed case with the victim's brother and sister-in-law. They were called first and then allowed to remain in the courtroom. We'll see what the prosecution chooses to do with that. But there seems to be ongoing either confusion, willful confusion, or disagreement with what's going on with these AT&T advanced timing records. And I've talked about it a couple times now. I've talked about it on stream. But with those records, they are a narrow subset of specific records from AT&T that were not available through AT&T's normal legal document center until 2023. However, there were ways to get them from AT&T in 2022. And in this case, the FBI did that for a number of phones, but not Bryan Kohberger's phone. And the defense pushed back on that and said, well, the government said these records weren't available in 2022. And I think the government's motion was unfortunately unclear in that, because in 2022, those records were available, but they weren't available for Bryan Kohberger's phone when they were requested. And I think that's where a lot of the confusion is on this, because I didn't read it when I went back and looked at it as the government said no one can get these records. The government said, as to Kohberger, these records weren't available. And technically, that's true. There is nothing in the record to indicate that when the government identified Kohberger as a suspect, those records were still available. Everyone from AT&T has said that those records have to be requested within a 7-day window of the targeted date. And in this case, by the time they were doing search warrants for Kohberger's phone after he was identified, that 7-day window from the time of the crime was long gone. But with the other phones where they got that subset of records, those were preserved within 7 days of the date of the crime in November. That's why those records were available to be downloaded and turned over. They sent a preservation notice before they sent a search warrant. They couldn't do that with Kohberger. He was not yet identified. When the defense put in their expert affidavit, the expert affidavit alleged that the prosecution was hiding information and alleged that it was an egregious hiding of information. The court pushed back strongly on that and called it the defense's conspiracy theory, well, the defense expert conspiracy theory, and was not pleased with how large those allegations were because they were based on conjecture. The prosecution filed their motion with affidavits showing that that 7-day window is the time period that narrow subset of records was kept in 2022. And the defense expert filed their affidavit after the prosecution filed that response and was completely silent as to that 7-day window. Did not say that wasn't true, did not say they had evidence that wasn't true, did not say that they knew for a fact that the government obtained those records. It was based on supposition saying, well, the government got these records for other phones, so logically they got them for Kohberger's phone. And when the government answered why that wasn't true, the expert remained silent on it, and we have not seen any updated affidavits or information. And when pressed on it in court, Attorney Taylor was not able to say, yes, we know the government received these records. Yes, we know that that 7-day window is not true, or anything else. She said at the end of that hearing, I want to be able to ask the FBI agent if he got these. And the court said, fine, you can do that outside the presence of the jury. And she said, that is all I wanted. So at the end of the day, there's no evidence that the defense knew that the government had those in their possession. And the government is saying, we don't have those and have never had those in our possession. I think this will come up again at trial. This type of record seems to be the most accurate way to determine where a phone is, because just pinging off a tower can be a very broad radius. And it's going to come up how detectives narrowed down the path of travel of Bryan Kohberger's phone before the phone was turned off after 2 o'clock in the morning on the morning of the murders. So we will see more fighting over the path of travel of Kohberger's phone. But I don't think the government is hiding information or is willfully withholding information or could have gotten to this information based on the information that we have. If that changes, it is going to be a huge problem for the prosecution. But everything indicates that the prosecution wanted that information too and wasn't able to get it because Kohberger was not identified quickly enough to allow them to get that information. I don't think it's anything beyond that. And the defense expert hasn't said that it's anything beyond that. The defense expert said these types of records did exist, but is completely silent to the fact that there was a limited amount of time those records were preserved up until May and June of 2023. So do I think this is the biggest deal in the world? Not yet, and not without more. Do I think that the court was incredibly displeased with how heavy the allegations were made? Absolutely. And that's what really got the court's dander up, was the leveraging of very large, unsubstantiated allegations. And the court said allegations of the kind that could get someone disbarred if true. The court said in his own words, this level of hyperbole is not helpful, and I will not tolerate these types of accusations without foundation in this court, and really put the hammer down on that. And truly, we saw Ann Taylor get the result that, after she backed up a bit, get the result that she was asking for. I want to be able to inquire from the FBI agent, and the court said yes. It's going to be interesting to see how this issue plays out or does not play out as we get into trial in this case. This case has been so sealed, and with the gag order, there's so little known that it seems that everything that comes out becomes a large deal because we don't have a scope or frame of reference for how much information there is in this case. I think that is going to be illuminating when we get to trial, because there is going to be a lot more that we don't know yet that is going to come forward. And this trial is going to start in August and last through November. There's going to be a lot more information here. Hopefully that clears things up. I saw a lot of questions about it. And again, if you disagree, please point out in the affidavit where he said something different, because I would love to see how you're interpreting it versus how I'm interpreting it. Because based on the hearing and based on my reading of all the documents, that's how I see it. And with that, thank you for being here for the Emily Show. Thank you for being a Law Nerd. Make sure you get the Law Nerd app so that you are in the loop on the cases that you love the most. And I will see you in court on Tuesday. It's time, y'all. It's time for trial. I'll see you in the next one. Take care of yourselves, take care of each other, and may the odds be ever in your favor. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.